Knight.
I am present.
Representative Agello.
Present.
Representative Batista.
Present.
Representative Bennett.
Here.
Representative Caldwell.
Present.
Representative Casimiro.
Present.
Representative Corvese.
Present.
Representative Felix. Representative Lombardi.
Present.
Representative Norrie.
Here.
Representative Place.
Present.
Representative Roberts. And Representative Bella Wilkinson.
Here.
Everybody's present, Chairman. We have a quorum.
Thank you, Madam Clerk. Welcome. It is Tuesday, March 9th, 2021. We're in the House Lounge. This is the House Committee on Judiciary. We have, we have two bills tonight scheduled for consideration. For those of you who are new or watching from television, that means we're going to vote on them. And then we have 21 bills to hear. So with reference to the first two bills, the first bill is House Bill 5093, sponsored by Chairman McNamara. It's an act related to motor and other vehicles, passing, use of lanes, and the rules of the road. It provides for specific fines and sanctions to operators of motor vehicles who fail to exercise due care to avoid colliding with a vulnerable road user, causing injury, serious injury, or death to the vulnerable road user. Is there a motion for passage?
I move passage, Mr. Chairman.
Okay, moved by First Vice Chair McEntee and Chairman David Bennett. So it's been moved and seconded. Is there any discussion? Seeing none, all those in favor signify by saying aye. Oh, I'm sorry, we have to do a roll call vote. Yep, short-term memory.
Chairman Craven.
Here.
Aye.
Yes, aye.
First Vice Chair McEntee.
Aye.
Second Vice Chair Knight.
Yes.
Representative Agello.
Yes.
Representative Batista.
Yes.
Representative Bennett.
Yes.
Representative Caldwell.
Yes.
Representative Casimiro.
Yes.
Representative Corvese.
Yes.
Representative Felix.
Yes.
Representative Lombardi.
Yes.
Representative Norrie.
Yes.
Representative Place.
Nay.
Representative Roberts. And Representative Bella Wilkinson.
Yes.
The ayes have it, Chairman.
Okay, that moves us to the next bill. That's House Bill 5092, sponsored by Senior Deputy Majority Leader Falella. It's an act related to domestic relations, passive voluntary adoption, mutual consent registry act, and adoption of children. It directs the Department of Health to provide information regarding the passive voluntary adoption reunion registry to the Department of Health's website in the Division of Vital Records. Do I hear a motion for passage?
I move passage.
Moved by Dr. Corvese, seconded by First Vice Chair McEntee. Is there any discussion? Seeing none, we'll have a roll call vote.
Chairman Craven.
Aye.
First Vice Chair McEntee.
Aye.
Second Vice Chair Knight.
Aye.
Representative Agello.
Aye.
Representative Batista.
Aye.
Representative Bennett.
Aye.
Representative Caldwell. Representative Casimiro.
Aye.
Representative Corvese.
Aye.
Representative Felix.
Aye.
Representative Lombardi.
Aye.
Representative Norrie.
Yes.
Representative Place.
Aye.
Representative Roberts.
Yes.
And Representative Bella Wilkinson.
Yes.
It's unanimous.
Okay. All right, so the bill passes. Next portion of our calendar is those matters scheduled for hearing and/or consideration. Can I hear a
I
motion?
move all bills held for further study.
It's been moved and seconded. Roll call vote.
Chairman Craven.
Aye.
First Vice Chair McEntee.
Aye.
Second Vice Chair Knight.
Aye.
Representative Agello.
Aye.
Representative Batista.
Aye.
Representative Bennett.
Aye.
Representative Caldwell. Representative Casimiro.
Aye.
Representative Corvese.
Aye.
Representative Felix.
Aye.
Representative Lombardi.
Aye.
Representative Norrie.
Yes.
Representative Place.
Nay.
Representative Roberts. And Representative Della Wilkinson.
Yes.
The ayes have it.
Okay, so the ayes have it. We'll move on to the calendar. There are two bills in which the Attorney General, who is present on our screen in front of us. Welcome, General.
Thank you, Mr. Chair. Good to be with you.
Yeah, I haven't seen you in a while. You've been, but I've been reading about you in the newspaper.
It's been one of those years.
Yeah, that's good. You feeling better?
Feeling great. Thank you.
Thanks. Okay, I believe the first bill is that sponsored, it's the last bill on our calendar. It's House Bill 5870. It's sponsored by Chairman Maslowski. It's an act related to labor and labor relations, payment of wages. It includes misclassification of employees as a violation of this section and would provide for increased penalties, including a felony where the wages due to the employee because of misclassification is greater than $1,500. General, the floor is yours.
Thank you, Mr. Chair and members of the committee, and thank you for having me with you tonight. This is a really critical bill. My overall instinct, as I think we'll talk about later, is not to bring more felonies to the table unless absolutely necessary. But this is one of those instances where in my view, plainly, it is necessary. Misclassification is a situation where an employer misclassifies employees as independent contractors, and they do that to save themselves money. Effectively, it allows them to treat what are truly employees over whom they have substantial control as something that they are not, and that is as an independent contractor. It means they don't have to pay them benefits. It means they don't have to pay them overtime. It means they don't have to contribute the kinds of payroll taxes that every other employer who's doing exactly the right thing has to do. And so that not only cheats workers, it cheats businesses that are doing things exactly the right way, and it cheats the taxpayers. Wage theft is slightly different. That's a situation where an employer literally steals the workers' wages. They simply don't pay them. They don't pay them for overtime. And that is happening in Rhode Island all the time. There is an underground economy, if you will, where this is happening on a regular basis. And both of these scenarios, these crimes, if you will, are treated today as misdemeanors. And if you think about it, you can steal literally anything else, anything other than wages, and that will be a felony if its value is over $1,500. If you steal my car, if you steal my refrigerator, if you steal a pet, that's valued over $1,500, that is a felony. But in Rhode Island, for whatever reason, if you steal a worker's wages, it is not. And I just think that is an injustice and deserves a fix. There's some practical additional reasons why, in my view, this statute needs to be changed. First of all, wage theft and misclassification cases are complicated cases. They involve typically substantial amounts of records. The easiest way to get those records is through a grand jury subpoena. However, because these crimes are misdemeanors, we cannot use the grand jury to obtain those records. The grand jury is an arm of the Superior Court. And so we're left with either getting a search warrant, which is substantially more difficult to get than a grand jury subpoena. So we're not able to effectively prosecute these or investigate these crimes. The other problem we have, and we have this in a case where we have brought charges where the defendants flee the jurisdiction, it is much more difficult to extradite someone back to Rhode Island to face justice on a misdemeanor charge than on a felony charge. We have a situation where two individuals stole the wages of their workers to the tune of nearly $10,000, and that's a lot of money to these employees, left the jurisdiction, and we are having difficulty bringing them back here to face justice. And so, to me, this legislation would fix what I consider to be a serious problem in Rhode Island that ought to be treated like other theft offenses, simply is not, and would do an awful lot of good for workers in this state. And so I would ask the committee to pass the bill out of the committee. Thank you, and I'm happy to take any questions you may have.
Representative Place.
General, Representative David Place, in a case where it's, say, a corporation or something like that, I mean, you just have stockholders and you've got an executive board, a chairman, CEO, et cetera, who would be the individual that would be charged with the felony?
Well, yeah, Representative, it's the same concept that applies in every corporate responsibility case. So whoever had knowledge and had decision-making authority would be responsible. That could be the foreman on a job, for example, if it's a construction job. But on the other hand, if the owner of the company knew what was going on and approved it, they would be responsible as well. It's the same principle of corporate and corporate decision-maker responsibility. That same concept applies to every state and federal crime.
Dr. Covesi.
Good evening, Attorney General Nerone. This is Representative Corvese.
Hello, Representative.
A good bill. Just curious, I have one question for you, one question for the chairman. Why $1,500 as opposed to $1,000?
Because, Representative, that is the standard misdemeanor felony value distinction that exists across all of the theft offenses under Rhode Island law. It used to be $500 when I was a young prosecutor in this office back in the late 90s and early 2000s. It's gone up over time to $1,000 to $1,500 by act of the General Assembly. So this would bring the dollar amount, the dividing line between misdemeanor and felony conduct, consistent with other theft offenses, which, when you think about it, is exactly what this conduct is.
Thank you, General. And to the chairman, did we pass something like this already out of this chamber?
We heard testimony about it, but it was last year, and we had that pandemic thing.
Okay,
So,
thank you. Thank you, General.
You're welcome.
Second Vice Chair Knight.
Thank you, Chairman. Good evening, General. How are you?
Good evening, Representative.
I just, it's a kind of a technical question, but I just don't understand why it's phrased this way. The sentence says, any employer who violates the misclassification statute would also be guilty of a felony if the violation was a knowing violation. So first offense, it's knowing, or a second or subsequent violation. Is there a scienter requirement on the second and subsequent? Am I just missing it?
Well, I believe that there is, and if that's unclear from the bill, there certainly should be. I mean, there ought to be, I believe, in most criminal statutes. Certainly, we would want to prove that, and I would think it'd be necessary to prove it. So if that's unclear, happy to work with the legislature, the committee, to make that more clear.
Right, so the intent is that every violation in the misclassification, or all the violations here are knowing violations, right?
That's correct, Representative,
Thank
yes.
you, General.
Okay, any further questions of the General on this bill? Seeing none, we only have one witness on this bill, General, so we'll get to your second bill as soon as Benjamin Brochard from the Carpenters Union. Benjamin?
Yes, Chairman Craven, how you doing?
You're on the air.
All right. Thank you, Chairman and Vice Chair McEntee and members of the committee for your time tonight. My name is Ben Branchard. I represent Carpenters Local Union 330 here in Rhode Island. I want to start by saying that our union has been coming before the House and in front of Chairman Craven at that time of the Labor Committee to discuss the wage theft in our industry for quite a few years. We've shared stories of elaborate chains of subcontractors subcontracting from other subcontractors, and the difficulty of holding anyone responsible when a worker doesn't get paid. We've talked about the issue of construction companies committing wage theft and tax fraud and simply dissolving or disappearing over state lines when attention's been called to it. We've talked about wage theft on construction projects that were essentially subsidized by the state through generous tax credits or tax increment financing, or paid for directly by the taxpayers. We've talked about all this stuff in the context of various bills that would have helped alleviate the problem over the years. And today, I think this committee has a real opportunity to to curb this issue, an issue that's costing Rhode Island tens of millions of dollars annually in missed tax revenue. House Bill 5870, which would make wage theft a felony under a structure similar to other forms of theft, helps solve the issue of wage theft not only by disincentivizing wage theft by increasing the penalties, of course, but also by allowing enforcement agencies like the Attorney General, who just talked about this, to pursue and investigate those cases across state lines via extraditing people who are charged with wage theft back here, which it's critically important, but especially in our heavily regionalized construction industry. So we are advocating for passage of the bill in full, and we appreciate the work that the sponsors have done to bring this before you. I don't think I'm going to get called again, so while I'm on the line, I'd also like to voice our support for House Bill 5384. Thank you.
Any questions of the witness? Seeing none, that would conclude testimony on House Bill 5870, which brings us to House Bill 6083, sponsored by Representative Slater. It's an act related to Food and Drugs Uniform Controlled Substance Act. It calls for reclassifying simple possession of 10 grams or less of a controlled substance in Schedules 1 through 5 of the Uniform Controlled Substances Act to a 2-year misdemeanor instead of a felony, which is current law. General, the floor is yours.
Thank you, Mr. Chair. This is a bill that was one of the first bills, or a version of this bill was one of the first bills that this office in my administration back in 2019 really focused on and felt very strongly about. In my view, this is a bill by reclassifying the possession of small amounts of any controlled substance from a felony to misdemeanor is an important step in criminal justice reform and removing obstacles along the road to recovery for those with substance use disorder, while at the same time not materially impacting what we're doing in the criminal justice system right now. You know, this case, and I want to be clear about this so that my words are not misunderstood. This bill is not about protecting drug dealers. If you are a drug dealer and you deliver narcotics, nothing is different. That remains a felony. If you possess narcotics with intent to deliver, that remains a felony. If you possess over 10 grams of any kind of narcotic, that remains a felony. What this is about is treating an instance where somebody possesses a small amount of drugs for personal use for what it ought to be, and that is a misdemeanor. You know, I prosecuted lots of big drug cases over the course of my 25-year prosecutorial career. And I know what a drug dealer is, and I know what a serious drug offense is. I've seen many of those offenses. At the same time, I've spoken around the state to parents of adult children who suffer from substance use disorder. When they talk about their children and are crying out for help for their children, I don't believe they view their children as felons, and neither do I. One of the most impressive acts of bravery I ever saw was at Westerly High School when a young woman delivered her senior project, which was to speak while I was there about her road from use of cocaine to heroin and then to recovery, about that journey. Did she view herself as a felon? I did not, and I certainly hope that she did not. The reality is, from my perspective, is that possession of a small amount of drugs is not a criminal justice issue. It's a health issue. And by turning this into a misdemeanor, which is where I believe it truly belongs, that allows somebody, when they're through, when they've completed the road to recovery, rather than have a felony on their record, they will have a misdemeanor. And that is a big difference. If you have a felony on your record, all of us know, this committee knows, given the nature of its jurisdiction, what a negative impact a felony can be on one's record, whether you're trying to get a job or trying to get housing or trying to get financial aid in many instances. And in my view, this conduct just does not warrant those kinds of consequences. In terms of expungement alone, to expunge a felony is 10 years after the probationary sentence or the suspended sentence or the jail sentence ends. So in theory, you could get a felony drug possession charge of a minor amount of drugs. And let's say it was 3 years, which was the maximum under the existing law. You'd have to wait 13 years to get that record expunged. For misdemeanor, it's obviously the time frame was much lower. In some instances, perhaps still too long, but much lower. So to me, this is about criminal justice reform, treating possession of small amounts of drugs for what it truly is, a public health issue, not a criminal justice one. And I guess I'll end with this. You know, we went back and looked at what I think we would all agree is the most serious narcotic that we're faced with dealing with today, and that's fentanyl. And when we would look back over 7 years of simple possession of fentanyl cases, what we found was that over that 7-year period, there were 228 such cases. In those 228 cases, 11 people went to jail. Those jail sentences were from 4 days to 6 months. And you could certainly make an argument, and I would not disagree, that no one should have gone to jail on those charges. But the fact remains is we're not treating those cases as jail cases now. So what is the point of labeling them as felonies? When I think of a felony case, I'm thinking of a serious case that many times ought to involve the potential of a jail sentence. If out of 228 cases involving the most serious controlled substance that we're dealing with today, only 11 people are going to jail anyway. What's the rationale for treating this as a felony when treating it as a felony has such a negative effect on someone's road to recovery? And that's why we have been supporters of this bill and have advocated for this bill each of the years that I've been in office. And I would encourage this committee to support it as well. I'm happy to take any questions. Thank you very much for your time.
Thank you. Questions for the Attorney General, Jose Batista.
General, how are you?
Hi, Representative. How are you?
Great. Thank you for being with us. I appreciate the effort in this bill. I know very well that very many members of my community, of the district that I represent in South Providence, have been devastated by the war on drugs. And to that end, I completely agree with everything you just said. My question is, if we recognize the damage that the hyper-criminalization of drug possession has done, why reduce it to a misdemeanor? Why not go further and decriminalize the possession of small amounts of drugs altogether?
Yeah, look, I mean, I think that's a debate, at least from where I sit, that remains to be had. I think this is an enormous step forward. I think the other thing that we've done in the area of drug reform is we've referred in my administration many, many more cases to diversion. And I haven't broken them out yet by, drug cases versus other cases. But I can tell you that in 2020, 25% of all felony filings were referred to diversion court. And so, we've made, I think, strong steps forward here in handling these cases, and diversion is another way to handle this issue. So, when we're taking both steps, I think, increasing the number of cases, including drug cases that go into diversion. Again, that's 25% of all filings last year. As well as making this step, I think it's a significant step forward, and I think it's the right thing to do.
Follow-up, Representative?
I just wanted to ask from a different perspective. Do you think, or do you have any concerns, does your office have any concerns with decriminalization? What would be the negative impact if you think there will be any?
Well, look, I think from our experience both in the drug court and through the diversion court, that certainly, and this is why we work with the Superior Court to stand up the diversion court, that where there is judicial involvement, and I think a 2-year misdemeanor is a critically important part of this, and keeping it in Superior Court is a critically important part of this, because it's through the Superior Court many times that services, substance abuse counseling services, are provided. And so I think if you were to simply decriminalize narcotics, generally speaking, then potentially access to those services, and frankly, the guidance of the court, which has been, I believe, very useful both in the drug court, the diversion court, the veterans court, that's run out of the district court, has been a very useful thing along the road to recovery.
Any further questions? Yes, Representative Norrie.
Thank you, Chairman. General, thank you for your testimony. The only problem I do have with the bill, sir, is the allowing of fentanyl. again, from a law enforcement perspective, as a retired law enforcement officer, 10 grams of fentanyl, 2 milligrams of fentanyl is considered lethal, and there's 10,000 milligrams in 10 grams. That's an awful lot of lethal drugs that we're going to make a misdemeanor. Now, I'm not talking about dealing, I'm talking about sharing. So to create an opportunity to share drugs at 10,000 milligrams in 10 grams that can kill many people, to make that a misdemeanor, I just, that's my sticking point with the legislation. Other than that, I totally understand where the legislation is going, but with fentanyl, I still have an issue. But thank you.
You're welcome, Representative. And if I could, that, your point is well taken, and it's why we went back and looked specifically at fentanyl cases, and we looked at them from 2014 through 2020, and that's why when we look at those cases and find that there are 228 of them, and in only 11 cases is anyone going to jail, and many of them, all of those folks are probation violators. And again, you can make the argument they don't belong, none of them belong in jail, but let's just take that number. That's a very small number. And what that number tells me is that we're not treating possession of fentanyl cases as jail cases. And so what we're doing by calling them felonies is not taking them seriously in terms of sentencing, because most folks are getting substance abuse treatment and they're getting a year probation or 18 months probation. What we're really doing is calling them felons. And by calling them felons, we're calling them felons for a very, very long period of time. And that has real life implications for them as they move into recovery. And as I said, try to get housing, jobs, et cetera, et cetera. And there's a substantial difference between a felony and a misdemeanor just in the space of expungement alone. We did expungement clinics last year where we helped over 450 people in person before COVID hit. And we've done it online since then. And I can tell you from talking to people at those expungement clinics where people have one thing on their record and they're waiting 13, 15, 18 years to get their record expunged, has a tremendous impact on them. And so if we're going to have that kind of impact, and that's a whole nother debate, then we ought to have it over something that, in my view, is truly a felony. And I don't believe that this particular conduct warrants felony treatment. We're not treating it as felony conduct in the courtroom because no one's going to jail. And if we're not treating it as felony conduct in the courtroom, then I don't think we should be treating it as felony conduct anywhere else either.
Representative Norrie, you have a follow-up question?
I do, thanks. It's more of a statement than a question. So we're talking about 230 cases, that was 230 or 270? But
yeah, 228.
So do we count the number of people that died from overdoses in those, right? And did we also count the number of people that were revived due to Narcan being used? So again, I don't think we're charging those instances and probably not counting those instances because we're looking at statistics where people were arrested for simple possession and charged. So again, with how lethal the drug is, again, we can agree to disagree. That's just, it really is my sticking point on being okay with this bill. And again, I totally understand what the intent of the bill is, and I 100% agree with that. I just have a problem with fentanyl being allowed to be an exception or included in this bill. Thank you.
Thank you, Representative.
Vice Chair McEntee.
Hi, General. It's Representative McEntee. I just had a question about the fact that you kept all the adjudications in Superior Court and you kept the prosecution with the Attorney General. I just wanted to know a couple of things. Why didn't you put it in District Court if it's a misdemeanor? But you can answer that. And also, is diversion still available to them?
Yes, Representative, and that's exactly why we did it. One of the reasons why we kept it in Superior Court. There are really two reasons. So why did we keep it as an office? There was some concern that by making it a misdemeanor that the office was, I don't believe this to be true, but there was some perception that we were trying to offload these cases to city solicitors and town solicitors and give them more to do. That was not the intent. But to reassure folks, I agreed that we would continue to do these cases ourselves. I also think we're best positioned to do them. Why Superior Court? Well, we wanted to make it a 2-year misdemeanor because we believe, looking back at the data, that most people need about a 2-year off-ramp to get through recovery all the way to the end. And so we felt that a 2-year misdemeanor in Superior Superior Court made a lot of sense. It's also where my most experienced prosecutors practice. You know, we have a relatively small presence in the district court. Our most experienced prosecutors, frankly, ones that have seen over the course of their experience, you know, truly what is a significant narcotics case and what isn't, are in the Superior Court, and I felt like they could be well handled there. And to answer your last question, yes, diversion is also an option. I think this allows us maximum flexibility. You know, some might say, well, if you have diversion court, why do you need this? Why do it at all? Well, we also know, you know, and I think, and I know that over time, you know, not everybody reaches recovery in exactly the same way. There are bumps along the road. We've all seen it. And this gives us maximum flexibility. Again, whether it be the drug court, diversion court, certainly on a misdemeanor, a Superior Court misdemeanor, these cases can be heard in the drug court. They could be diverted before they're charged in Superior Court. So there are lots of ways to handle these cases, and I think one thing we've learned is that flexibility, Representative, is very important.
Thank you, General.
You're welcome.
Any further questions of General Nerona? Yes, Representative Knight.
Thank you. Hello again, General. I want to do a follow-up to Representative Noray's question, and I'm just wondering, my feeling is from practicing in the system every day that we are essentially, when it comes to narcotics crimes, possession only, not trafficking, that we're essentially running not so much a criminal justice system where we say you're bad and we extract punishment because society says that this is bad, but we're running kind of a drug treatment program administered by the court system. So it seems to me that getting all wrapped up in the lethality of the narcotics is not the correct focus if you're thinking about what we're doing is trying to heal people rather than punish people. I wonder if you have any thoughts about that idea. Am I in the ballpark, or am I totally off base?
No, you're right, Representative. I agree with you, but I also recognize that there are points of view from others that, you know, fentanyl is such a dangerous substance that it ought to be treated differently than others. And that's why we went back and looked at the data. And I guess my point is, and I don't know that I'm articulating very well, but I guess my point is that if we're treating even fentanyl cases as non-jail cases, then what that tells me is that we are, as we should be treating them, as not so much criminal justice cases, but public health cases. And so even fentanyl cases don't warrant a carve-out. You know, if fentanyl cases, simple possession, again, we're not talking about people who are delivering fentanyl to somebody else. We're not talking about somebody who possesses fentanyl with the intent to deliver it. We're not talking about somebody who possesses large amounts of fentanyl. We're talking about somebody who clearly has fentanyl for personal use. For those individuals, even in that most significant and serious of substances, we are not treating them in the criminal justice system as jail cases. To me, when you're talking about a jail case, you're talking about a felony. Okay, if we're not treating these cases as jail cases, then they're more properly classified as misdemeanors. Misdemeanors, as you know, Representative, are not jail cases, generally speaking. There are some exceptions, domestic violence cases, certainly instances where someone's a probation violator, but first-time offenders and misdemeanors are not going to jail in our system. And so these cases are not jail cases, even with fentanyl. And so my point is that if we're treating them that way inside the court system, then what we shouldn't be doing is classifying them as felonies, because all that felony classification does is stand in their way when they're trying to get housing or when they're trying to get student aid or get a job 3, 4, 5, 6, 7, 10 years down the road. We're over-criminalizing something. We're not treating it as a felony in the courtroom. Why treat it as a felony elsewhere? That's my point.
Thanks, General.
Representative Lombardi, you have a question.
Thank you, Mr. Chair, members of the committee. General, how are you?
I'm doing well, Representative.
Yeah, good. So in effect, we are changing the definition of the word misdemeanor in this particular incident, with 2 years. Does that also mean a $2,000 fine, or is that am I just reading into it?
It means up to a $500 fine, I believe,
Okay.
Representative. You know, one thing it does do, this bill also takes out minimum fines. You know, if you're looking at trying to get people back into the workforce, these fines are a tremendous problem. I mean, there's lots of other legislation up there. I won't get into it right now. But for example, it costs $100 to get your record expunged. Many of the people who need their record expunged can't afford that $100, even though they're eligible. So what we're really trying to do is make sure that the fines are limited to where they're really important and eliminate minimum fines.
Will this affect, I'm sorry, just a follow-up, will this affect the definition of other misdemeanors? So that's my next question.
It will not.
Is the next thing going to be, assault's going to be, domestic assault's going to be, or whatever, assault's going to be 2 years, or is that going to have any impact at all?
No, it will not. This is a specific 2-year misdemeanor. And again, that 2 years is really because, from talking to both the court and our experience across the various treatment courts that we have, that for many folks, and from speaking to folks who do counseling, 2 years is about what you need. You certainly need more than a year in most cases, with court supervision and treatment supervision to get down the road far enough into recovery that then you can move off of probation. That's really what we're talking about.
But couldn't we just extend the jurisdiction of the drug court? I mean, I just had a case, someone was a heroin addict, and 9 months, they were gone. They were fine, I mean, there was some other issues going on, and I'm just wondering, it's just, like misdemeanor, again, will that have an effect on, you were charged with a misdemeanor, you got a 2-year probation. Is it going to affect, as you stated, housing, getting a loan, getting a job, not being able to attend your child's ball games or their school events? Just trying to think out loud.
Yeah, well, this is going to make that situation better because it's a lot harder to do that under the current law where the same conduct is a felony. So, you have to say, you don't have to, check the box any longer thanks to the great work of the General Assembly, but you still have to disclose it during your interview that you've been convicted of a felony, to get your one felony in your life of possessing 3 grams of heroin, to get that expunged. If you get right now a 3-year suspended sentence, you've got to wait 13 years. If that's a misdemeanor, as it is here, it's 5 years after. Well, some might say it's still too long, but it's 5 years. It's certainly better than 10. And what you're telling an employer or anyone where you want to volunteer, to the extent you have to answer it at all, because I was convicted of a misdemeanor as opposed to a felony. Remember, this is about This is not a drug dealer. This is not somebody who possesses drugs with intent to deliver it. This is not somebody who possesses a large amount of drugs. This is about a small amount of drugs for personal use. This is really a public health issue, in my view, not a criminal justice one.
It is a public health, it may be a disease, and the question is, 7 years is too long, too, in my humble opinion, but that's just my humble opinion. Thank you, General, appreciate it.
Thank you, Representative.
Any other questions from members of the committee of the Attorney General? I don't see any, General. Thank you. You might want to stay on. There's one more witness that you may recognize his name, Mayor Jorge Alorza.
Thank you.
Okay. Okay, I guess the mayor is busy now. He's going to ask us to call back in a little while. Thank you very much, General. Appreciate your testimony and your time.
Thank you, Chair. Thank you. Thanks, everyone.
Take care. All right, the next matter is one of our members, Representative Chairman Vella Wilkinson, has to get to finance, and she's got some big testimony down there in reference to the lottery. So we will deal with her bill, which is on page 1, House Bill 5384. It's an act related to Food and Drug Uniform Controlled Substances Act. It reclassifies certain simple possessions of drugs as a misdemeanor instead of a felony.
Thank you, Mr. Chairman and fellow representatives of the committee. To frame House Bill 5384, I share the perspective from the Urban Institute in discussing how drug felony convictions affect people and their communities. We are in the midst of a mass incarceration crisis that has damaged families, harmed communities, and deepened racial disparities in the criminal justice system. Reclassification legislation offers more than reductions in prison use and related savings. It ensures a reduction in felony convictions, which carry significant consequences and costs to communities. Across states, people with felony convictions are subject to numerous employment restrictions and bans, impeding them from finding and keeping a job. Limiting employment opportunities contributes to high recidivism rates for people returning from incarceration and high unemployment rates for the communities to which they return. One study estimated that felony convictions cost the United States as much as $87 billion in annual gross domestic product. All this is in the face of mounting research that incarceration isn't an effective response to drug abuse. A Pew Charitable Trust study found there's no significant relationship between rates of imprisonment for drug offenses and rates of drug use, overdose deaths, or drug arrests. Meanwhile, research suggests that community-based treatments produce better public safety results for drug abuse compared with incarceration. In closing, I think that Utah Governor Gary Herbert said it best. We can't just warehouse people. There needs to be rehabilitation, especially for nonviolent offenders. There ought to be a better way to do this so we don't have a revolving door. I would like to now turn the microphone over to other community stakeholders to testify on this bill. Thank you.
If it's all right with you, Chairwoman, there's about like 22, 23 witnesses on this. If we could get back to that and get rid of some of the chair people that are waiting around for no other reason.
Absolutely.
Would that be all right with you?
Sounds good.
'Cause I saw Mayor Jorge Alorza on here as well, and I know that he's unavailable right now. So I'll hold off on finishing testimony on this, and I'll go to House Bill 5185, sponsored by Chairwoman Serpa. It's an act related to commercial law, general regulatory provisions, purchase and sale of precious metals. It requires a licensed buyer of certain precious metals or articles, tools, and electronics to take a digital photograph of their purchase and upload it to the Attorney General's license sales tracking system database.
Well, thank you, Chairman. That's the bill. I can sit down now.
There you go.
No, just kidding. Back in 2003, I had a constituent who was actually a detective in the West Warwick Police Department at the time bring a bill to me asking that any items that are sent to brought into a pawn shop for resale would be described in a database. Things like jewelry, musical instruments, what else might be stolen in a house break? Cameras, works of art, that they have to be described in a database so that if my house has been broken into and I go to my local police department and I describe the item, it would be incumbent upon the detectives to pursue that based upon a description. Well, the same constituent brought me an extension of this bill, and this time he is suggesting that the person who is accepting the item for pawn actually take a digital photograph and upload it into the let me see if I can get it right, LSTS, the License and Sale Tracking System. He contends that a picture is worth 1,000 words, and I might say that a 14-carat diamond ring was stolen in a house break, but if it's a 14-carat diamond ring and I know that there's a nick in a special spot, if I can see that ring in a picture, I might be able to identify, and there's no back and forth with the detective trying to go back and forth with descriptions, verbal descriptions, minus a photo. So that's basically what this is about, and I believe he's being asked to be called in to testify, so I don't know how you're handling all of those testimonies, Chairman.
Well, there's one person signed up, Chairwoman.
Yeah.
It's Steve Alves from the
okay.
Rhode Island Pawn Brokers Association.
Okay, so are you taking him now, or?
Yeah, we'll do that right now.
Okay,
Yeah.
all right.
So if there's no questions for the sponsor by members of the committee, then we'll call up former Senator Stephen Alves.
That a picture is worth 1,000 words.
Steve.
Yes.
Last time I saw you was in Aruba. How you doing?
I know.
Good. How are you?
Good. You're on the air to testify on Pat Serpa's bill, on pawnbroking.
Okay. All right, let me turn Pat off because I'm still listening to Pat, so there must be a delay.
There is.
Thank you, Mr. Chairman and members of the committee. I rise in opposition. I sit in opposition to this particular bill, and while I think the bill is certainly well-founded, it needs some work, and we're willing to work with the sponsor and the local members that are concerned with this. Currently, right now, under current laws for in-state pawnbrokers, they do digitize photographs and do make a description. However, it's unevenly put out to certain shops and certain items. And what's happening right now is the state system, first of all, can't handle if every single thing in this bill were to put into practice. An upgrade of all the computer systems would need to be had. Second of all, it's unevenly doing. Certain pawnbroker shops have to do it, but yet art dealers or sports memorabilia dealers or bullion dealers are not required to do this under current law. We think it's redundant and excessive on everything that has to happen. I mean, for most pawnbroker dealers, the average price item coming in is $200, and over 50% of the items that go in are actually brought back to the original owners. You know, they go in there, they use it as short-term funding for their own particular needs. Believe it or not, you'd be quite surprised to go into a pawn shop and realize one of the biggest things that people take in are their TVs and VCRs for short-term money. And so with that, we're opposed to the legislation as it's written, but certainly we do think that this needs to be updated and clarified, and we'd be more than willing to sit down with the people who are interested in this, along with the Attorney General's office, which I think is a vital part of this program. Thank you.
Any questions of Senator Alves? Seeing none, that concludes testimony on House Bill 5185. We bring this to the next bill sponsored by Chairwoman Serpa. It's House Bill 5470. It's an act related to criminal procedure. It creates an act authorizing any person who has been sentenced to imprisonment greater than 1 year subsequent to being wrongfully convicted of a criminal offense to petition the court for an award of compensation and damages, including attorney's fees. This is a bill we heard last year. This is known, I guess, anecdotally as the Hornoff bill. It's a fellow named Scott Hornoff who was a Warwick police officer convicted of murder and was 6 or 7 years later found to have not committed the murder. So, Representative Serpa, I know this is near and dear to your heart. He's a good man, and I guess he's available to talk tonight, so you can go ahead and present the bill.
He is, Chairman. Thank you very much. You know, you have heard this bill for 2 years in a row, and it has been passed overwhelmingly. I think 64-0, 1 year, 67-0, another year. There are several new people on this committee, but Representative Place, I think you were here for those votes. And we have a couple of young members, God bless them, who probably weren't even born when this was certainly a scandal that rocked not only the city of Warwick, but the state of Rhode Island. Mr. Hornoff, and this is not the Scott Hornoff bill because this is about reparations and restorative justice. And I just saw last week another man was found innocent of a crime. He served 10 months in the ACI and he was released. But Scott, unfortunately, he spent 6.5 years at the ACI for a murder that he did not commit until the real murderer stepped forward and confessed to the murder. So Scott was released, and frankly, the sad part of it is when someone, and I learned this by working as well with the Innocence Project, when someone in this state, and in this instance, Scott Hornoff, he was released as a free man with fewer rights and benefits than someone who is released after serving his or her time. No access to health care, no access to job training, no access to assistance with housing. They give him what was in his cell in a brown paper bag, and they say goodbye, good luck. One thing before you listen to Scott, and it really is a personal story, so he can tell it better than I. In working with Scott and with the Innocence Project, on page 3, lines 3 to 5, this is where we're asking the committee to maybe give us a little assistance, because if we pass the bill again in our chamber, I seem to be challenged on the other side, but if we pass it again in our chamber, Scott and the Innocence Project and I discussed the coordination of eligible services to be coordinated through the Department of Probation and Parole, and we couldn't come up with a healthier, better alternative, but it was Scott's impression that, frankly, this could trigger PTSD for someone having been wrongfully convicted to return to the ACI. So I said, well, you know what, why don't we leave it to the committee to put their heads together and maybe come up with a better alternative for this coordination of services. So that's something we're going to put on you, if you don't mind. And I'll be happy to answer questions, but Scott has a way better story than I to tell.
Any questions of the sponsor? Seeing none. Scott, are you on the air? Scott.
Yes, sir.
Bob Craven.
How are you, Chairman Craven?
Good. It's been a year, and you're on the air. So, please, if you wouldn't mind, tell your story again.
Representative Serpa suggested that I go through my whole story because there are some new members there, so that's what I intend to do.
Good.
Good evening, and thank you for the opportunity to testify. My name is Jeffrey Scott Hornoff, and I spent 6 years, 4 months, and 18 days of a life sentence wrongfully imprisoned in Rhode Island's prisons for a murder I didn't commit, and I'm in support of this bill. Every step of the judicial system put in place to protect innocent people like you and me failed me and failed my loved ones. If not for the guilt and remorse of the one responsible and him coming forward to confess, I'd be in prison tonight instead of speaking with you. While no amount of money could ever make up for the time I lost, this legislation would provide the financial compensation and support services that wrongfully convicted Rhode Islanders like me need to rebuild our lives. I was raised in Warwick and currently reside in West Warwick. In 1975, I was 12 years old and attending Windman Junior High School when my brother Dave was accepted into the Rhode Island Municipal Police Training Academy as a recruit for the Warwick Police Department. As a way for him to get into shape, he decided to start jogging, and he talked me into joining him. During our runs, he spoke with me about the police academy, and then after he graduated, he talked with me about the police work, and I developed an interest in a career in public safety. From the ages of 12 through 21, I continued jogging with my brother, and my interest in the criminal judicial system grew. I became a Warwick Police Reserve officer, enrolled part-time in criminal justice classes at Bryant and CCRI. I worked as a store detective at the malls and waited for my opportunity to follow in my brother's footsteps. In 1983, I attended the police academy for Warwick, graduating second in my class. I was also the fastest runner. I loved being a cop, whether it was pushing a disabled car out of the road, being part of the dive team, or helping to hold dangerous individuals accountable for their actions. I loved my job and I miss it very much. In 1989, I was a newly promoted detective, and I was also for a short time a suspect in the murder of a friend named Vicky Cushman, who was killed in my city. Unfortunately, my department conducted an incompetent investigation. However, eliminating me as a suspect was one thing that they got right. During the next 3 years, Vicky's murder went unsolved. Unbeknownst to me, the state police had been assigned to investigate me again. One afternoon in May of 1992, I answered a knock at my door, finding 2 Providence Journal reporters on my front steps. They asked me if I had any comment about being the state police's main and only suspect in Vicky's murder. A single and focused investigation ensued. I was unaware that they'd been assigned to solely target me in their investigation rather than to investigate the crime. The following day, the story was on the front page, and for the next 4 years, I was vilified by local television and print news as the only viable suspect. Opinion pieces and commentary was published stating that the city of Warwick could not begin to heal until I was tried, convicted, and put away. My brother and I were ostracized by our department and by so-called friends, causing Dave to eventually move out of state. It took 2 grand juries to obtain an indictment against me, and I was allowed to testify at the second one. An elderly man slept and 2 women thumbed through a bridal magazine, not really interested in my testimony. Plates of food had been brought in to celebrate the holidays and my pending indictment. Jurors were caustic towards me and to others who testified. I was charged with first-degree murder and made bail thanks to my mom putting up her home. I was suspended without pay by my police department, and I applied for jobs with over 80 businesses without success. My ex-wife and I couldn't pay our mortgage and moved into the basement of my mom's house while we tried to sell ours, eventually having it foreclosed on. I told the state police detectives they were going to take me away from my family and my life for something I didn't do, and they did. My trial lasted 6 weeks and was sensationalized by our local media. With no evidence or witnesses linking me to the crime scene because I wasn't there, in June 1996 I was convicted of first-degree murder. I was shackled, led to a basement cell, my belt and shoelaces removed. I was strip-searched and eventually driven to prison. I was housed with murderers, sexual predators, the mentally ill, and others. And over the course of the next 6.5 years, I was double bunked with some of the most vile and disgusting men you don't want to imagine. Visits with loved ones was the best and worst part of prison. It was the best because it was my main connection with humanity, but it was the worst because my family and friends had to go through all of the security measures, then see me in prison garb, and then leave without me while I'd endure another humiliating strip search. There have been research studies undertaken which show that extreme stress, including that caused by wrongful imprisonment, even changes brain chemistry, and maybe that's what's often referred to as post-traumatic stress. I know I went a little crazy in there. The option of suicide became a frequent consideration for me, and I wondered each day if that would be the day I'd finally had enough. I often thought it was a way to free my loved ones from our ordeal, but I also knew if I did that, then everyone who was wrong about me would never know it, and my family's name would always be tarnished. So I fought on, knowing full well that mine was truly a life sentence, since one condition of parole was a confession of guilt, and I never would have admitted guilt to something I didn't do. I reminded myself that better people had endured far worse and that my children were mostly healthy and safe. As difficult as my wrongful imprisonment was, I can't imagine what it was like for my family. My wife was pregnant with our 3rd son, and he was born with a heart condition 3 months after I was locked up. She had lost her job at MetLife due to a company refocus and had to find a place to live. I asked her for a divorce so she could try to have a life and not be chained to me in the prison. My oldest son, Joshua, was 7 years old and was suddenly the man of the family. My boys grew up during their formative years without a dad. Joshua would end up babysitting his little brothers from a very early age. But all of the pain that the rest of us felt must pale in comparison with what my mom endured. I wish she was alive today to share with you in her own words the pain and heartache she experienced. I know that the anguish she felt for over 10 years contributed to her early death, but at least she was there to see me released. The emotional, mental, physical, and financial toll taken on me and my family is difficult to describe. I won't go into too many details about my and my family's financial losses, but it was devastating. We lost our home. I lost my career. Our home has since more than tripled in value. My mom sold her home, the one that we all were raised in, for half its worth to pay attorneys and investigators and for DNA testing, as well as for the outrageous collect call phone bills from prison, and I never had an opportunity to pay her back. In prison, I walked the toughest beat of my life with no backup. When I was released and declared innocent, the city of Warwick and its mayor decided I had been properly terminated when my state appeal was denied. I was stunned to learn that I would be forced to sue for reinstatement. The department I had worked to be a part of since the age of 12 had completely turned its back on me. It's no easy thing to relive this even in a prepared statement. not so much because I'm scraping old wounds. I've given dozens of guest lectures, but because I will be one of the people benefiting from this legislation. I have no problem asking for assistance, donations, or services when it benefits someone else, and I was pretty good at doing that while a police officer and through fundraising for the Rhode Island Special Olympics, and as I've done for the New England Innocence Project since my release. But it's difficult tonight. I remind myself that this is going to help others too, and that it's time that Rhode Island got on board with this. Rhode Island is one of 14 remaining states without a law providing assistance to exonerees. 4 days ago, Idaho Governor Brad Little signed the Wrongful Conviction Act into law, providing state compensation for the wrongfully convicted. This makes Idaho the 36th state to adopt a wrongful conviction compensation law. And Oregon is considering one right now, too, that will provide $65,000 a year plus support services. Idaho's new law provides a fixed sum of $62,000 for each year of wrongful imprisonment, or $75,000 for each year wrongfully served on death row. The average amount offered nationally through state compensation laws is $68,000 per year. The $50,000 per year in the bill before you tonight is a figure that former President Bush proposed for exonerees at the federal level, and if adjusted for inflation would be approximately $62,000 today. When exonerees are released from prison in states without this law, they are provided with no services or support of any kind, while men and women who actually commit crimes and are paroled receive housing, employment, counseling, and health insurance assistance. Parolees should be supported and assisted, but so should exonerees. I was exonerated in 2002, receiving nothing from the state, not even an apology. In fact, some tried to blame me for my own imprisonment while spreading falsehoods, and I was forced to continue to fight in court from 2002 through 2006. My reinstatement to the Warwick Police Department and back pay was ordered by Superior Court Chief Justice Rogers. In 2006, I received $600,000 in back pay, of which my attorneys received $232,000, and my ex-wife received the remainder by order of a family court judge. I did receive my police pension. After my wrongful imprisonment and then what I went through in family court after that, I dropped my federal lawsuit against the state. I had had enough of courtrooms. In 2007, I was invited by former Utah Assistant Attorney General Creighton Horton to testify before the Utah Senate Judiciary in support of a wrongful imprisonment compensation bill. The committee voted the bill out unanimously. Debate went from the previous sessions, why should we give exonerees that much money, to why can't we give them more? While it was heartening to me to help exonerees there, I've been frustrated these past 19 years trying to garner interest and get a bill passed here. I thank Representative Serpa for championing this effort for the past 3 years and for the support voiced by all the representatives and senators I've met at our State House. In closing, I want you to know that every exoneree story is unique, tragic, and filled with loss. Although the number of exonerees in Rhode Island is quite low, there is a need for this legislation. This bill will not empty Rhode Island's treasury, but it will help America's and Rhode Island's newest subculture. Thank you for supporting this bill, and please make it the best you can.
Any questions of Scott Hornoff? Jose Batista.
More of a statement as opposed to a question, but I just wanted to thank the witness for your extraordinary courage and how well you've articulated and humanized your experience. I think that one of the most unfortunate parts of our criminal justice system is how it labels some people as quote-unquote criminal or quote-unquote guilty, and they're never to be heard of or thought of again. And so I think your testimony is going to go way beyond this room in terms of helping to make the average person understand that our system is flawed and the devastating effects it can have. So I just really want to appreciate you for your strength. I can imagine how traumatic and difficult not only your experience is, but having to relive it and repeat it. And I'm deeply grateful for your testimony and participation. And thank you to Chairwoman Serpa for her work on this issue as well. Obviously, I am expressing my utmost support, and I wish you all the best.
Thank you, sir. It means a great deal to me.
Any other questions? Oh, yes. Vice Chair McEntee.
Hi, Scott. It's Representative Carol McEntee. I want to thank you for your testimony. And I just want to say, the system is based on all of us feeling like we'd rather let the guilty go free than imprison an innocent man or woman, and it certainly failed you. And as I have in the past, I support it again, and thank you, Chairwoman Serpa, for bringing this bill back. And I hope you get your justice this time. So thanks for sticking with us, and I hope you're well.
Thank you so much. Third time's a charm. I'm feeling really good about it this year.
Good.
Any further questions or comments for the witness? Thanks, Scott. We'll go to the next witness. Elizabeth.
Thank you, Chairman.
You're welcome. Elizabeth Powers, Innocent Project.
Hello?
Elizabeth?
Yes.
Hi, how are you? It's Bob Craven. I'm the chairman of the Judiciary Committee, and you're on the air.
Oh, thank you so much. I really appreciate it. My name is Beth Powers. I am a state campaign director for the Innocence Project. The Innocence Project is a national organization dedicated to exonerating wrongfully convicted people through post-conviction DNA testing and reforming the criminal justice system to prevent future injustice. We work with our local partners across the country, including the New England Innocence Project, on policies to prevent and address wrongful convictions and compensate those who have been exonerated. I'd like to begin by thanking Representative Serpa for her leadership in sponsoring this, and for all of you who have signed on as co-sponsors, and all of you who have heard this bill the last 2 years and given it such tremendous support. We really appreciate it, and we really hope that you support it again this year. Last year, when you considered this bill, as Scott just mentioned, Rhode Island was one of 15 states that lacks a law to compensate the wrongfully convicted, and today that is 14 states. And we urge you to help bring Rhode Island into the vast majority of states that do compensate the wrongfully convicted. Most wrongfully convicted people spend years behind bars fighting to prove their innocence, and they face a number of challenges when they first get out, that Scott just outlined, but also they lose key years of building a career, of saving for retirement, of all of those financial milestones that we take for granted in the prime of our life. There's no way to make up for the injustice we just heard from Scott. There's no way to make up for those years, but it's imperative that states have in place mechanisms to compensate the wrongfully convicted, not just for Scott, as we just heard, but for whoever gets out in the future, for that person whose innocence is yet to be proven. One of the changes to the bill that Representative Serpa mentioned is the language surrounding how services are to be offered to exonerated people. So 20 states, there are 36 states with laws to compensate the wrongfully convicted. 20 states offer non-monetary services, so what this provision does. And as you'll see, 5470 offers access to and eligibility for any services provided by the state for offenders who have been adjudicated by the courts and are residing in the community, and coordination of said services shall be through the Department of Probation and Parole. We greatly appreciate that. That is an improvement from last year's bill. However, exonerated people may be hesitant to engage with the correctional system that had wrongfully incarcerated them. And so we encourage you to consider services offered through a non-correctional entity. Many states do this by adding exonerees onto a state health plan or offering tuition waivers. One proposal could be to allow exonerees access to eligible services by the Department of Human Services, or access to a Department of Human Services counselor that could facilitate connection to the services. And all of this is in my written comments. Some of you may have great suggestions on how to do this. I just want to be really clear that even without a change to this, we strongly support this bill. It would be a huge step, and we urge its passage. I'm happy to answer any questions you may have.
Any questions of Elizabeth Powers? I see none. Thank you, Elizabeth. The next witness is Radha Najarian. Hello, Radha?
Hello.
Yes.
Yes.
You are on the air, and you're representing the New England Innocence Project.
Yes, thank you so much, Mr. Chairman. Yes, my name is Radha Natarajan. I am the Executive Director of the New England Innocence Project. Our organization corrects and prevents wrongful convictions throughout New England, including, of course, in Rhode Island. And I want to start by thanking, as others have, Representative Serpa for introducing and championing this bill to provide compensation to the wrongfully convicted in Rhode Island. And I also want to thank each of the members of the House Judiciary Committee for considering this proposal again this year and for your support. Before I was the executive director of the New England Innocence Project, I was a public defender for 12 years. And during that time, I had many clients released from prison to parole or probation. Each one of them, convicted of crimes that they committed, had more services and support upon their release than a single one of my innocent, exonerated clients have now. Unfortunately, the nightmare of a wrongful conviction does not end once a person is able to prove their innocence and their release from prison. Instead, upon release, most exonerees have little or no financial resources left. Some missed out on critical years when they may have gone to school, they may have gotten job training, built a career, saved for retirement. Exonerees are released most often without any assistance to meet their basic needs, such as housing, health care, transportation, day-to-day expenses, and not to mention addressing the trauma of wrongful imprisonment. And you heard at least one story of that by Scott tonight. It's difficult to imagine the extent of the loss that one suffers after a wrongful conviction, and we know that it's impossible to restore someone back to where they were before they were wrongfully imprisoned, and we can't give them back the years they lost. But there is something meaningful that we can do to help innocent people restore their lives. And Rhode Island remains just one of 14 states that does not have a statute to compensate those wrongfully convicted in the state. Typically, the only recourse for an exonerated person to receive any monetary assistance in a state without a compensation statute is for them to file a federal civil rights lawsuit, which typically leads to a lengthy and difficult battle for the wrongfully convicted and for the taxpayers. The burden and costs associated with litigating such a case are so high, successes are few and far between, and monetary relief, if any, lacks uniformity. So the wrongfully convicted person, like Scott, must not only prove that mistakes were made, but that there was deliberate or reckless conduct on the part of officials. And in most cases, even if there was misconduct, official actors such as police, crime lab personnel, and prosecutors, they're shielded by doctrines that we have heard a lot about in the last year, absolute or qualified immunity. Exonerees are re-traumatized by having to relive the experience of incarceration. They are asked to prove all the ways they suffered from the wrongful conviction just to get some amount of compensation. And in those cases where there is a successful lawsuit, there's still no guarantee that they'll recover any damages at all. In other words, those lawsuits, they're just not a substitute for the kind of streamlined, uniform, and fair process of a state compensation statute like the one before you tonight. Scott Hornoff is a Rhode Islander who we know was tragically wrongfully convicted for a crime he didn't commit. He served 6 years in prison. He missed out on years of raising his family and losing the career that he worked so hard to build. He was released without any assistance, and he's been left to rely on his family to support him, even though he was wrongfully convicted by the state. For the few Rhode Islanders who have suffered the unique horrors of wrongful conviction, House Bill 5470 would ensure that they can get the financial help they need to recover and rebuild their lives. That's why the New England Innocence Project strongly recommends passage of this. And thank you so much for hearing me tonight.
Any questions? Seeing none, thank you very much. And the last witness on this bill is Joshua Hornoff. Joshua?
Hi, this is Josh.
How you doing, Josh? You're on the air, and you're here to testify about Scott's bill.
Yes. Am I on?
You are on.
All right. I want to thank you, representatives, for the opportunity to speak today. I'm going to keep this pretty brief. I've previously spoken on behalf of my father, pushing for one of these bills before, and my stance remains the same. I'm very much for it. As a person who has witnessed firsthand someone, in this case my father, be wrongfully convicted of a crime and taken from their family, I find it pretty hard to believe that something along the lines of this bill is not already in place. Wrongful convictions devastate lives, not just of the individual put behind bars and mixed in with some of the worst people who actually do belong to be there, but it also tears apart the families of those convicted. So much time I could have had with my father was taken as a result of the wrongful conviction that plagued my family. So think of any happy memory you had with your dad growing up. I was never allowed to have that memory. All my memories are sitting across from each other in a prison visiting room. This bill cannot replace the time stolen from families who are victim of wrongful convictions, but it can help them get back to something close to normal. I know from my experience as a result of the wrongful conviction of my father, I lost my childhood home and grew up in poverty while my mother worked as hard as possible to keep a roof over our heads. So I advise you to please support this bill. If you or someone you loved was stolen from you for no real reason, you would hope there would be something in place to help you rebuild. And without this bill, there really isn't. Thank you.
Any questions of Joshua? Thank you, Joshua. That concludes testimony on House Bill 5470. Thank you very much, Chairwoman Serpa. That was a great job. The next bill is House Bill 5467, sponsored by Chairwoman Williams. It is an act related to criminal offenses, criminal sexual activity. It grants immunity to commercial sexual activity persons if they are victims/witnesses of a crime. Chairwoman Williams.
Thank you, Mr. Chairman and members of the committee. This act would ensure that they feel safe in coming forward to report crimes and are able to report exploitation or violence committed against others. This applies if individual reports the crime to a criminal law enforcement agency, seeks or receives health care services as a result of the crime, or assists or attempts to assist in the investigation or prosecution of the crime. If the victim or witness later withdraws cooperation due to safety concerns, physical or emotional health, or any other reason, the victim or witness shall not be charged. Most of these individuals are victims themselves of horrendous crimes, and we must not penalize them for reporting crimes done to them or committed in their presence. If we truly want safe streets that are free from trafficking, exploitation, and pain, we must incentivize these workers to feel safe and free enough to report the crimes that they witness or become part of. And that's my testimony.
Any questions of the sponsor? Okay, thank you, Chairwoman Williams. We have four witnesses. Melissa Brodo is the first witness. Melissa, you're on the air.
Yes, hi. Thank you so much. Thank you to Chairman Craven, and thank you, Chairwoman Williams, for introducing this really important bill. So thank you. I'll be brief. I am a longtime attorney and advocate for all people in the sex industry. And for many, many years, I did direct client representation in New York City, where I would advocate for my clients, many of whom were victims of severe crimes. And, you know, I think it's a difficult decision for anyone who is a victim of a crime to come forward and report, but most of us don't have the burden of fearing that we will be arrested if we come forward to report that we've been raped, assaulted, etc. And my clients who were engaging in sex work or presumed to be engaging in sex work always had to weigh that concern in reporting violent crimes against themselves. And so I am so excited to see that Rhode Island is considering this, along with so many other states this legislative session, New York, New Hampshire, Vermont, Montana, and Nebraska. And in 2019, California passed legislation permitting similar immunity. So I think this is immensely important. If we don't provide some protection, we're going to see history continually repeat itself. You know, we had Gary Ridgway, the Green River Killer, who killed over 60 women, almost all of whom were sex workers. And in New York, we had the Gigolo Beach murders in Long Island, still unsolved, in large part because the police department locally refused to grant immunity to sex workers or their clients who had important tips about this serial killer who is still 10 years later at large. So, you know, it's incredibly important that everyone have access to safety in their person. Thank you so much.
Thank you very much for your testimony. The next witness is, are there any questions of the witness? Oh, yes, Representative Felix.
Thank you, Mr. Chairman. I just have a quick question. In terms of a case like this, like a person that has trying to come forward regarding a sex offense or trying to advocate for themselves, what are the penalties that they would be facing should this law not be in place? I don't know if you can answer that.
Hello, Melissa? We'll have to get back to her, if you don't mind, thanks. Henry, BYNX?
Yes, Henry, thanks. Yes.
Oh, hi, how are you, Henry? You're on the air. Henry, you're on the air. Henry?
Hello?
Yes, is this Melissa or Henry?
This is Henry.
Hi, Henry. You're on the air. You can proceed with your testimony.
All right. First off, I'd like to thank you for making an audience for me to speak to support the bill that's on the floor tonight. So when I was fleeing the abuse of my husband in Central Vermont, there came a point where I had to come and reclaim my belongings from a domicile that I shared with him. My husband was prone to emotional and physical violence, and for that reason, I brought 2 people with me for protection. But in this last encounter, I was denied access to everything I owned, and when the police were inevitably called to action, they simply instructed me to gather only what I could carry. While I was packing, though, one of the officers was asking me what I did for work to kind of fill in the time and detract from the severity of the situation. I did tell him my profession, that I'm a farmer in the summertime and an exotic dancer in the winter. When this came to his attention, I was rushed off the premises, and no justice ever came for my husband's actions. So although the call was made for protection against my husband's violence, not a single step is taken on behalf of the police department to protect or investigate. As a result, my husband fled with much of my belongings and the domicile that was intended to belong to me. I was rendered homeless in a Vermont winter, and I don't know if you all have ever experienced those, but they're nothing nice. And history has kind of repeatedly shown us that when sex workers cannot come safely forward and perpetrators are aware of this vulnerability, serial crimes do occur. I appreciate you taking this time for me tonight. Do you have any questions?
Any questions of the witness? Thank you. Seeing none, the next witness is Hannah Stern, ACLU. Melissa?
Hello?
Melissa?
Yes, I'm here.
There was a question of one of the representatives of you. I'll give her the floor.
Sure.
Thank you, Mr. Chairman. Hi, Melissa. This is Representative Felix. I just have a quick question to see if you have the answer for it. But when a victim of a crime or a witness of such crimes come forward, what are the penalties that are imposed on them by police department that re-victimizes them? Do you happen to know?
Sure. So I think it depends, which I know is the answer that every lawyer gives in every situation. But essentially, for my clients, I was with the Sex Workers Project in New York City for many, many years. If I went with a client who had been, let's say, raped by a client of theirs, a sex work client, and they reported that rape was occurring in the, during prostitution, they had the risk of being arrested for prostitution. We were lucky enough, again, for New York City, and I'm, in sort of more progressive pockets where police hopefully don't do that, but it certainly shouldn't be an individual choice. It should be a statewide law, which is why it's being considered in New York and so many other states, in addition to Rhode Island, that people can come forward without being afraid of being arrested.
Thank you. So essentially, without this bill, we're re-victimizing people who already been victims of such heinous crimes against themselves, their bodies, and traumatizing them even more. I just want to express my strong support for this bill and thank the sponsor for bringing it forward.
Thank you.
Any other questions for Melissa? Seeing none, the next witness is Hannah Stern from the ACLU. Hannah Stern?
Hi.
Hi, how are you? You're on the air.
Thank you. Thank you, Chairman and members of the committee, for your time this evening. My name is Hannah Stern. I'm testifying on behalf of the ACLU of Rhode Island in strong support of this legislation. I'd like to thank Representative Williams for another piece of legislation which would really provide very important protections to sex workers. The statutory protection that this bill would provide would ensure that sex workers can report abuse or violence or seek help if needed without having to weigh the consequences of any legal ramifications against their need to ask for assistance. So this only makes the lives of sex workers safer and better protects their autonomy, and we urge passage of this important bill. So thank you for your time and your consideration. I'd be happy to take any questions.
Any questions of Hannah Stern? Seeing none, the last witness on this bill is Randall Rose. Randall?
Yes.
Randall, you're on the air in reference to House Bill 5467, and as I always ask, could you please be brief? We have a long calendar tonight.
Understood. Thank you, Mr. Chair.
Thank you.
Yes. So I am testifying in favor of this bill, and people who are in the commercial sex workers are often subject to a lot of abuse, and some of them are not really in the trade voluntarily, and they're a lot of times they do get exploited. I think it's important to make sure that they have the opportunity to report crimes against them, including sexual crimes against them, without being at risk for prosecution. I think we usually place a high value on preventing sex crimes, but and sexual assault. But if commercial sex workers are going to be subject to prosecution if they report crimes, their sexual assaults and other coercion against them is going to go unpunished. So I think it's important to support this bill. Thank you.
Thank you very much, Randall. Are there any questions of Randall? Appreciate your brevity, Randall. You'll be back tonight later on, I can see. Okay, that concludes testimony of House Bill 5467, which brings us to two bills I'll put in play, both sponsored by Minority Whip Chippendale. The first bill is 5991. I'll get the explanation in a second.
Thank you, Chairman.
All right, you want me to put it in play for you?
Yes, please.
The first is 5991. It's sponsored by Minority Whip Chippendale. It's an act related to criminal offenses, burglary, and breaking and entering. Adds a rebuttable defense. If any person shall die or sustain a personal injury while committing robbery of the owner, lessor, or occupant of a motor vehicle, and that owner or occupant of the vehicle acted in self-defense. And the second bill that I'll put in play, and Minority Leader, or Leader Chippendale will address both of them, is an act related to criminal offenses, burglary, breaking and entering, and it provides a rebuttable defense if any person shall die or sustain a personal injury while committing any violent criminal offense. That individual is lawfully in a place they have a right to be and acted in self-defense and a reasonable belief of harm. The floor is yours.
Thank you, Chairman and honorable members of the House Judiciary Committee. These two bills are very similar in nature. One, as was pointed out by the chair, is fairly specific to motor vehicles. The other is to homes and property. We've all heard the expression that a person's home is their castle, and that is where the term the castle doctrine originated. We enjoy the ability to defend our castle. This bill, or this act, seeks to amend our existing castle doctrine to recognize recent court decisions, or court decisions in general, that have exposed some areas where we could use some work to perhaps be up with some of the other states, but also just to catch up with the court's decisions in the state of Rhode Island. Not, as most of you know, not being an attorney, and this being an extremely detailed and complex area of law, there are experts who are on the hook, so to speak, to testify, and I imagine you'll be hearing from them shortly. So I would be more than happy to answer with my limited ability any questions that the committee may have. Otherwise, I think for the technical questions, it may be best for the experts who testify to direct those questions to them.
Are there any questions of the sponsor of either bill? Yes, Jason Knight.
Hi, Representative Chippendale. What's wrong with the current law, which has a duty to retreat when deadly force is contemplated?
So again, the experts who will testify after me will get into, specifically in your language, exactly what's wrong. However, there are some areas that I can't talk about where, as you're well aware, as a criminal defense attorney, when you are inside of your home under certain circumstances, you have the ability to defend yourself, your family, your home. There are areas to which that is also extended in the law under certain circumstances. Such a place might be my barn if I'm out taking care of my livestock, and again, certain circumstances exist. That castle doctrine would offer me protection there. However, were I walking between the barn and the house, I would not be protected whatsoever, according to my understanding. Once again, emphasizing that I am not an attorney. So I think it may be best, specifically considering your years of criminal defense work, to direct those more succinct legal questions to the experts who testify, Rep.
Dr. Craven.
I think it's a good bill, Representative Chippendale. Obviously, I co-sponsored it. But let me just say that I think you're going to have to rethink that walking between the home and the barn. I think if you're on your property, the castle doctrine is extended to your property.
And again, Representative Chairman.
Because of recent events that happened over the last 6 months to someone's property, I made discrete inquiries regarding whether or not the Castle Doctrine extended to one's property, and the answer I got back was yes.
And I look forward to listening back to the testimony when that question is more succinctly answered by a legal professional.
I think we already did your... Any other questions?
Thank you very much, Chairman.
Representative Chippendale. There are several witnesses that are in comment, so with your permission, what I'm going to do is I'm going to go on to a couple of other either no witnesses or very few witnesses.
Yes, of course.
And then I'll go back and I'll place both bills in play, and I'll ask witnesses that have called to testify on both, so that we can get everybody a chance to be heard without having to repeat it in reference to each bill. Is that all right with you?
Thank you very much for your indulgence. I appreciate it.
Thank you very much for
Everyone have
your
a good
patience.
evening.
Okay, we'll hold off again on House Bill 592 and 5991. Those bills we'll be back to very shortly. We've got a few bills that have, I guess I said little or no witnesses. The first is the bill sponsored by Chairwoman Fogarty. It's an act related to criminal offenses, public utilities. The floor is yours and the bill is yours.
Oh, yeah, I'm sorry. Okay, thank you, Chairman, and to the rest of the Judiciary Committee. House Bill 596 would increase the criminal penalties for intentional or malicious interference with our electrical and communications infrastructure, or introduces a contaminant or tampers with our drinking water supply. 2 years ago, I put in this bill. I had some pushback on the amount of criminal penalties that I had put in the bill, but I don't think that I don't think $50,000 is much to put as a penalty and some jail time, since these penalties haven't been changed since 1938. So we need deterrence for people who would think about going after our electrical, our water supplies, and so forth. I see how people get very, very mad at snowstorms recently, or when they just lose their power or gas lines or something happens with them, how it can really disrupt your life, your job, running government, all those different things. And actually, we've become even more dependent in this past year of COVID on use of our electrical equipment. We're all at home. We need to keep functioning as best as we can. So I looked up drinking water. I used to just have the electrical and communications infrastructure, and found out that the water supply, tampering with that, was at $50,000. So I was really in the ballpark, I do believe, with this bill. So I would say that this bill would deter all types of people who would consider disrupting our infrastructure, and we as legislators have to take it serious that we want to protect our infrastructure. Things are different these days. Types of tampering can come from people stealing things, going in and getting copper, to people who really want to cause major harm. It didn't happen around here, but just in February in Tampa, when the Super Bowl was going on, somebody tampered with, it wasn't a foreign country, it was considered to be somebody less astute than a foreign country affecting the water supply. But what they ended up doing is they started tampering with the water supply while the Super Bowl and people were in the town, adding a percentage, increasing the percentage of sodium hydroxide, which is lye, into the water. There is controls that some of the management have that can be away and adjust the water control. Somebody happened to look at the screen and started seeing that the dial was starting to get turned up. So a nightmare could have happened in Tampa, Florida. It could happen pretty much anywhere who has these types of remote adjustments. I'm not sure I was trying to look up what's been the follow-up, if they found anybody. But again, people can get a hold of, you can have a disgruntled employee, some type of an insider threat. These people need to be punished, and we have to protect our infrastructure. We have a big, big problem outside the world with bigger countries trying to affect our infrastructure. I don't think this is going to deter them, but anybody else who wants to get a little bit of smart with their computer in their basement and start trying to figure out ways to affect our electrical or anything else that they can get their hands on, I think we need to increase the penalties, since we haven't done it since 1938. Be happy to take any questions.
Any questions of Chairman? Yes, Representative Chairman and Dr. Fogarty, Dr. Covesi.
Chairwoman, how are you this evening?
Very well, and yourself?
I kind of like this bill. I have two questions. First, what was the impetus of this? Was this something that you came of your own volition, or was there something that you read, or was some group that came to you and asked to put this in?
I have a brother-in-law who is a lineman for the electric company, and he sees a lot of damage that's done, and he gets very upset.
Good impetus for a bill.
Yes.
Personal experience. The second one is, since I'm not a lawyer, and this could be to yourself or any of the lawyers we have a plethora of lawyers here. Could this in any way be interpreted where it could be turned against a utility for a bad snowstorm, flood, wind, what have you? Could this be turned against them? Because I understand the intention, I believe, of a chairwoman is, we're talking about something malicious, wanton, willful.
Right.
Something of a nefarious nature, if you will. Granted. But I'm just wondering, could the subscribers for National Grid, Verizon, Cox, could they somehow use this against them to sue them? And again, not through any nefarious purpose, but because, and she alluded to the fact, people complain about legitimately, where their utilities aren't turned on because there's a, natural problem. And yes, we like them to be a little bit more efficient, we like them to be a little bit more rapid with their response, but I'm just wondering, could this somehow be inadvertently turned to that?
Well, I can have legal counsel, who's here now, but take a look at it, but you want to redress it?
I think it's a great bill.
Language on page 1, entries to electric or, sorry. If you read the language on page 1, line 4, every person who shall wantonly or willfully and maliciously cut, destroy, break down, injure, and it keeps going on and on. So, I mean, you definitely have to have ill intent.
Yep, okay,
So,
and
that's
what I-
already in there.
And that's good,
That's on page 1, line 4.
okay, and I guess I was looking at, in the beginning, where it said, to the manual or electronic operation of a switching mechanism by other means, that sounds more of a legitimate nature or institutional for the company. I think it's a good bill, the intent is a good bill. I just want to make sure that we're not somehow trying to make it so that we're going to penalize National Grid or Verizon or Cox for acts of God.
Yeah, I think Vice Chair McEntee was saying that. I think it does give a pretty good description of the type of malicious intent that would be directed, so that it unless we have, people going out and cutting lines and stuff like that from the electric company, I don't think that happens. They're out there busting their tails to get the power back on all the time. So this is really trying to protect them, their side of it. I don't think you could use it. I think other people will go after National Grid for having power issues, so that's a whole separate can of worms.
Very good, thank you.
No problem.
Representative Place.
You said a family member had brought this to your attention. Could you give an example that he gave as to what he's seen?
Well, what they've seen is sometimes in the substations, that people go down into the substations and they'll steal, is that me? They'll steal some of the copper, sometimes, and leave stuff down there that will cause explosions, so some people can, I don't know who that is. So that's what they've seen. I guess it was me, I'm sorry. It's the electric coming off of me on this electric bill. So things of that nature have happened where they've had a lot of damage in a lot of the substations, pull things apart. Sometimes they've had people blow things out, that in these substations over the period of years, or they've left just a lot of damage. And I mean, that's, I'm electric. So that's some of the examples. And I think even that the gentleman who, not that that would happen locally, but what just happened on Christmas Day, that hasn't been figured out yet, but who brought that camper in front of the Bell. To me, I thought about this bill, and I'm wondering if he was trying to stop, was it Bell, or it was one of the big telephone companies down in Memphis, Tennessee, when they blew up the whole building, and I'm like, I wonder, there's just a lot of people out there with a lot of different ideas, and again, this is just meant to try to be a deterrent, and if somebody is trying to do something, then we give them some jail time and we penalize them.
I've just never seen where just increasing a penalty for a crime acts as a deterrent. I mean, I understand updating it in terms of the technological aspect of it, but I think it's just, I don't know, it goes against a lot of what I believe in, just to increase a penalty. It doesn't sound like you're increasing a penalty for deterrent, because the penalties aren't deterrents. You're just trying to punish them.
This criminal time also has been increased on these bills too, if you look, so.
Oh, yeah, I understand, that's what I'm saying. Anytime you do that, to say that it's a deterrent, the penalty is never a deterrent to committing a crime. It's just a way to punish somebody for it in the end.
So, I'd hope it would deter some, but you're right, maybe it won't.
Representative Batista. Good evening, Representative. Thank you for this bill. It seems, I was to echo the comments before, it seems like a very appropriate bill, something we're very concerned about. I was just wondering how intentional, if at all, was the decision to take it from a maximum of 2 years to a maximum of 10 years. And I can understand the restitution part, obviously, pay for whatever damages you broke.
Damage is correct.
That's one thing. But I have a little bit of concern with raising the criminal time from 2 to 10 years for two reasons. One, similar to what Representative Place was saying about the deterrent, folks generally are not thinking about that. And two, from a policy perspective, what generally ends up happening is that those 10 years, for example, number one, they're used as leverage to try to ultimately force someone into a plea because they don't want to face what's coming on the other side of the trial. And second, I generally feel like we are moving as a society and as a state away from these longer sentences, because what happens is folks are on probation, let's say 5, 6, 7, 8 years, you're doing a really good job for the majority of that time, and at the end you get caught up and you still have to pay penalties for something that happened so long ago. And so I'm wondering if there's a way, or if it makes sense, to emphasize more the compensatory damages, the literally paying for what you broke, as opposed to quintupling essentially the maximum criminal penalty.
I think the attempt really, for adding the amount of years, was really to, depending on what type of activity was involved. I mean, it's more or less like kind of a range that you go to 10 years. If you actually are able to get in and do something and cause some type of harm or some major electrical, never mind just paying for the reparation, I think you'd want somebody to probably serve a higher amount of time. Again, depending how, like look at the person who adjusted the lie in the Tampa water system. If some people, that could have been a big tragedy. If somebody didn't happen to be looking at the screen and started seeing that being turned and increase, you had thousands of people who were there, extra people in town for the Super Bowl. I mean, if people started drinking that and started dying, I think you'd probably want like a 10-year max. I don't want to see that happen, but I think that's kind of the thought on, things are strange, things are different these days. Cyber type of crimes are increasing, and they can affect our industrial grid, and I think that's probably why we were looking at that type of a year. But I'm flexible if you wanted to decrease it, but I think that's why we were trying to look at a higher rate depending on what type of activity was done.
Thank you, I appreciate that.
No problem.
You have a follow-up question, Representative Place?
Yeah, I mean, I think what you're describing is more of a domestic terrorism event, which I think there are plenty criminal penalties that would be ascribed to it, as opposed to someone scrapping. I think there's a big difference between domestic terrorism and someone scrapping. I think you bring both of those crimes into the same law, just based on your description of it. I'm not sure if I understand.
Representative Price, I don't mean to interrupt you, but it might be my mindset. I do work for industrial security at Raytheon, so it might slip out and I might start talking that way. I think that way at work, but this is really to try to do minor type of hopefully minor type of things, but we could have a major event. You can have somebody in their basement starting to affect how to, adjust types of our infrastructure locally. I'm not talking about national events. That is something that our national security institutions would have to look at, and I think are seriously looking at it now. But I'm just saying locally, for our infrastructure, what happens here, you could have somebody in their basement starting to try to affect something that's happening locally here. And that's what I'm trying to look at. I apologize if I start to sound a little bit more global. That's just my job. Sorry.
Thank you very much.
I mean,
Any
I would
other
still
questions
say-
of the sponsor?
Yeah, I would still say, like I said, if you've got somebody sitting in their basement trying to, mess with the electrical grid or the water system or something like that, that is more of an act. Again, you're comparing this want act versus scrapping. I'm worried about the little guy that's out there, again, they're scrapping and all of a sudden they're going to get caught up in this thing. So that's my primary concern with the legislation. Thank you.
You asked me for an example, I gave you an example, but there's a whole list of other different types of things that could happen. I would refer you to the first page and the first paragraph of the bill. Okay? Thank you.
Any further questions? Thank you. There are no witnesses that signed up, so that concludes testimony on House Bill 5986.
Thank you, everyone.
Thank you very much. And that takes me to Senior Deputy Majority Leader Falella's bill. It's an act related to animal and animal husbandry. It specifically provides that as a violation for any person leaving a dog outside unattended in temperatures from 32 degrees Fahrenheit or below to 90 degrees Fahrenheit or above would be subject to a fine not more than $1,000.
Good evening, Mr. Chairman and members of the committee. I am bringing to you House Bill 5736. This was brought to me by Dennis Tabella from the Defenders of Animals. And this is current law in the state of Pennsylvania right now, where an animal cannot be left outside longer than 30 minutes in 32 degrees weather or above 90-degree weather. And they use what's called the Tufts Weather Scale. I heard this week from the American Kennel Club, you might have that in your packet.
We do.
They were a little bit concerned with some of the wording because they mentioned to me about huskies or dogs that are used for police work, dogs that hunt birds. So they did mention that. I know they had some concerns, along with DEM today did call me, and they also had some concerns, and I think he has something there in the packet as well. But I believe Dennis Tabella is on the line, and I think he could explain a lot better, but I could try if anybody has any questions.
If there are no questions, oh, yes, David.
Didn't we do a bill similar to this with Joe Sullivan in the
That's
Tufts
what
bill?
the DEM brought to my attention today, that there is a similar, and he was afraid that this would
Yeah,
kind
offset
of
it.
overlap. Yeah, so you're right about that.
Thank you.
Thank you. Thank you, committee.
Okay, Dennis Tabella? Dennis Tabella, you're on the air.
Thank you, Chairman. I wanted the committee to know that there's only one municipality that has an animal control officer on duty after hours. But to compound the issue of cities and towns not having an animal control officer to respond after hours, we have the issue of animal control officers interpreting the existing laws differently. The laws that I'm talking about are the ones that pertain to dogs left tied outside in bad weather. There are numerous factors to consider in the existing law that specifically talks about the Tufts weatherization scale, which is part of the existing law in Rhode Island. Unfortunately, some animal control officers are using these factors in the wrong way, and they're not all interpreting it the same way. So I think that one of the things that the state of Pennsylvania found out was that there were too many moving parts, so to speak, and dogs just weren't getting treated properly when they're left outside in bad weather, especially freezing weather. So Pennsylvania has the same wording in their law that has been introduced in your committee. Now, one thing the committee needs to know is that Pennsylvania, of course, has over 12 million people, compared to Rhode Island's 1 million plus. So there are a lot more dogs and a lot more complaints for a state like Pennsylvania to handle, but they found that the wording in the bill that was introduced in your committee is working much better than the Tufts weatherization law that we have in place now. And I know that there are some people that think that dogs like huskies can be left outside in the cold, but not all huskies are equal. You have to consider their health, their hair, their age, and a number of other factors. And I don't think we're talking about huskies that are fit enough to be used in the Iditarod, and we cannot expect animal control officers to examine the condition of each husky out there. So what we're in favor of is protecting all dogs in inclement weather. And I think that this bill does exactly that. I don't think there's a question about any animal organizations that are involved with animal rights or animal welfare that does not support this bill. And I'm speaking on behalf of Defenders of Animals, the Humane Association of Northwestern Rhode Island, the Smith and Agley Potbelly Manor from North Kingstown, and I think a number of other agencies, including VSA in Providence. So we would hope that this committee would vote in favor of this bill. I think it has a lot of support in Rhode Island. Thank you.
Thank you, Dennis. Any questions for Dennis? Seeing none, the next witness is Stacy Ober from the American Kennel Club. Stacy, you're on the air.
Thank you, Mr. Chairman, members of the committee. My name is Stacy Ober. I'm the advocate in New England for the American Kennel Club. And the American Kennel Club has been around for 135 years. We're a not-for-profit animal welfare organization that promotes the study, breeding, exhibiting, and advancement of purebred dogs. I just want to acknowledge we do have 10 dog clubs in Rhode Island, and I'm calling tonight to express concerns with House 5736. I wanted to acknowledge that the American Kennel Club is in favor of protecting all dogs as well, which is why I'm expressing concern about the way the language is written. The bill says that a dog could not be left outside and tethered for more than 30 minutes at temperatures below 32 degrees or temperatures greater than 90 degrees. And when I look at the current statute, animal cruelty statute, at section 412A, there's language there that already addresses the prohibition on leaving dogs in, let me read it to you, anyone who willfully fails to provide that animal with proper food, drink, shelter, or protection from the weather. So my concern is that enacting this would hamstring an animal control officer because they'd have to wait at least 30 minutes before taking action for a dog whose health condition maybe didn't allow it to stay out in temperatures even under 90 degrees. I have a bulldog, and they can't tolerate high temperatures. Also, the health condition of the dog should be taken into consideration, as well as the age. And so it's our interpretation that current Rhode Island law would satisfactorily allow an animal control officer to address these situations. And in fact, the penalties are more significant than the proposed $1,000 violation. If you read section 412, subsection A, the offense comes with imprisonment for not exceeding 11 months or to be fined not less than $50 to $500 or both. So I think this would create some confusion for animal control officers, and I don't believe the bill is necessary given the current provisions in state law. I'm available for any questions.
Any questions of the witness? Okay, thank you for your testimony. That concludes testimony on House Bill 5736. which brings us to two bills sponsored by Representative Lombardi. I'm going to put both of them in play at the same time. The first is House Bill 5575. It's an act related to criminal procedure. It establishes Rhode Island first step requiring corrections to assist offenders with reintegration into society, counseling, medical care, education, early termination, to pre-release confinement for elderly and terminally ill offenders. The second bill is House Bill 5878. It's an act related to criminal procedure, identification, and apprehension of criminals. It allows expungement of multiple felony convictions for nonviolent felonies 20 years after the sentences are complete. Representative, the floor is yours. And he's gone. Oh, that's good. Well, I don't want to wait all that time, so let me go to the next bill, and then we'll go right back to Representative Lombardi. Next bill is sponsored by Representative Cortovan. It's an act related to State Affairs and Government Commission on Standards and Training. The floor is yours.
Thank you. I hope I don't make it start humming. Good evening. Thank you, Chairman, and thank you, committee members. I am here to introduce H5393. This bill would require the Police Officers Commission on Standards and Training to provide police officers and detectives and those that serve in that role of a detective with training to help them identify and recognize when an involved person, either a victim, a suspect, or a witness, has either a cognitive or communications-related disability, and how to appropriately respond. National statistics on this tell us that police officers receive about 168 hours of training on the use of force compared to about 10 hours of mental health training. According to the ARC National Center on Criminal Justice and Disability, 50 to 80% of an officer's encounters are with a person with a disability. The disabled are much more likely to be the victim of a crime, and by law, people with disabilities are equally entitled to the same level of access to law enforcement services as provided to those without disabilities. So putting this training into statute would prevent our law enforcement agencies from encountering liability issues. And obviously, an officer's lack of awareness in one of these situations can lead to tragic results. And
any questions of the sponsor? Yes, Justine.
Thank you, Chairman. Thank you, Rep. Cortvrend. Does this also apply to SROs? I know I have some parents in my district who have a lot of concerns about their children and other students like them at their schools with the SROs, making sure that they interact with students with disabilities in this manner that you're talking about here.
it applies to all police officers. It would apply to people coming out of the academy and to police officers that are on the job now.
Yeah,
So,
that's great.
but
They'd
that's
be
a
really
great
happy
point.
with that. Thank you.
That's a great point. And we may have, I think we have at least one witness on the call list, but I don't know if you're going to take those right now.
Yes, I will. I know Randall Rose has signed up, and Bob Marshall has signed up as well,
Correct.
but he has no position. So does he still want to testify to your knowledge?
He may.
Oh, okay.
He
All
brought
right.
me the bill from the Developmental Disabilities Council.
Correct, thank you. Robert Marshall. Bob, how are you? Bob Craven, you're on the air.
Chairman Craven, Bob Marshall here. Thank you for giving me the opportunity to appear on behalf of the Rhode Island Developmental Disabilities Council on this bill. This is a bill that we have been working on for quite some time. And actually, we had done a demonstration project similar to the bill over from 1988 to 91, where we spent over $100,000 showing how this could be done, working with the Providence Police Academy, as well as the state police and a bunch and several other departments, and trained quite a few police officers. Unfortunately, when we finished up the demonstration, no one was able to pick up and keep going, and most of the officers that we trained, which were quite a few, have now moved on to either administrative positions or retired. So the training kind of fell by the wayside. But we feel that this is something that's very important for officers to be able to deal with individuals that have communications issues, ranging from autism to deafness to speech impediments, that kind of thing, and also people with cognitive issues when they are interacting with the police. Then the last piece of this bill is the piece that looks at what to do when you're investigating and a witness or a victim or the person being investigated has one of these issues. So we're looking at also to have training for detectives and for officers that perform investigations to go forward with this. We think that it's something that needs to be done. Most of the police officers we've talked to also feel that they need some help in this area. We did do a study commission a few years ago that was chaired by former Rep. O'Grady. And we heard from a lot of people on their issues not being able to be prosecuted because the investigatory piece of it was not able to be done due to lack of training. So I'd be happy to take any questions on this, and we hope that the committee would give this good consideration and look at moving it forward this year.
Any questions of Bob Marshall? Seeing none. One last witness on this matter is Randall Rose. Randall, you're on the air.
Thank you, Mr. Chair and members of the committee. I, too, am in support of this bill. People have made most of the points that need to be made, but I will just say that we do have a lot of diversity in our society. People have different disabilities in communication and cognitive disabilities, and you can't treat everybody the same way. Sometimes you have to know a little about how to interact with people who have different conditions or different disabilities. I think these are very useful skills, and I can understand why a lot of police officers wish this bill was passed so that they could have the skills to deal with all the different types of people who they encounter, or at least more types of people who they encounter. So I think this bill will really help, and I hope it gets passed this year because it has come up repeatedly. Thank you.
Thank you very much, Randall. That concludes testimony on House Bill 5393, which takes us back to Representative Lombardi's two bills that I put in play. Representative Lombardi, I assume you can hear me. Testify on them, would you, if you wouldn't mind, on 7.5 first and 7.8 second.
Okay, it's easier the other way, Mr. Chairman.
Okay.
If you want me to do it that way, that's up to you.
You're the judge in real life.
No, you're the judge. I'm sorry about that. But yeah, thank you, Mr. Chair, and members of the committee. And so anyway, 5878. What it does is it looks at someone who, people with multiple felony convictions, certainly not crimes of violence, no rape, no murder, things, all the things that are, I mean, this is right out of the expungement statute. This is just, adding more language or increased language that would allow people who have been charged with, a couple of felonies with some misdemeanors to be allowed to expunge their record 20 years after completion of their sentence. So, we've often talked about how these barriers that are created, certainly affects the less affluent communities, people of color, and not only in housing, in jobs, and, every aspect of life, but, even things like, to go to attend their child's school events or their sporting events. So, this is a whole. I mean, if someone were to get, a 3-year sentence for a felony, they're 18, now they're 21, and then they get, another felony, another 3 years after that. You have to wait, the 20 more years, and then, that person's going to be in their 40s. Now, what does that mean? That may mean a promotion. That may mean housing. That may mean, the ability to get a loan. That may be the ability to attend their grandchild's schooling events or their sporting events. So, this has implications, certainly within the less affluent and the communities of color. So, it's something that's certainly near and dear to me, and I would ask, you please consider this. And I would endeavor to answer questions. I will try to. Probably won't be able to, but if you have any questions, I will attempt to answer them for you. Thank you, Mr. Chair, members of the committee.
Any questions of Representative Lombardi on 5878? I don't see any. You can go on to the next bill.
Okay. Mr. Chairman, this one, 5575, this has a little more meat to it, and it's certainly was a lot of work, and this was, based on statutes involving federal concerns and trying to apply it to the state. And this act would establish Rhode Island's First Step Act and require the Department of Corrections to assist offenders with reintegration into society, provide them with counseling and medical care, education, and provide for early termination or relocation to pre-release confinement for elderly and terminally ill offenders. It also, there's a section there about, prisoners, female prisoners that are pregnant, and how to deal with that, and, giving people some dignity, give some clothing, give some education. Part of the recidivism problem is that, people go in prison and they conspire all day long. Some of my clients, that's what they told me, we had nothing to do, no education programs, no this, no that. But it has two things. It cuts unnecessarily long sentences, and it will try, at least attempt to improve conditions in prison to stop recidivism and to create individuals who can function in society or as they attempt to re-enter society. And what this is, it's a template, again, dealing with age, dealing with sickness, dealing with, pregnant women, and just trying to make people functional as they re-enter society. And it's fairly comprehensive, but I will endeavor to try and answer the question. Mr. Chair, I want to thank you for taking me, and as I promised you, I would try and be less than 3 minutes. Thank you, sir, and members of the committee.
Any questions of Representative Lombardi, the sponsor of the bill? John, I don't see any, so thank you very much for your presentation.
Thank you, sir. I appreciate it.
Okay, take care. Thanks.
Okay.
The next matter is House Bill 5880, sponsored by Representative Kislak. I think I see her. There she is. It's an act related to delinquent and dependent children, and particularly proceedings in family court. The floor is yours.
Thank you very much, Speaker, members of the committee. It's a pleasure to join you remotely tonight. The ACLU came to me with this bill a few years ago, and I am glad to be bringing it before the committee for consideration tonight. It's one of those things that shouldn't happen at all, but evidently it still does, which is that children who are in custody should not be questioned without a parent or a guardian present. And so this bill would tighten up that standard and clarify that expectation. So I'm really glad to bring it before tonight, and I know the ACLU has some testimony. I don't know if anyone else has signed up on this bill.
Randall Rose has, but
Thank you.
any questions of the sponsor? Okay, with that, we'll go to Hannah Stern from the ACLU. Hannah, you're on the air.
Can you hear me?
I can, yep.
Oh, perfect. Thank you, Chairman and members of the committee, again for your time this evening. My name is Hannah Stern, testifying on behalf of the ACLU of Rhode Island in very strong support of this legislation. And I'd also like to thank Representative Kislak for her continued advocacy around this extremely important bill. We're really appreciative of her support on this issue. So perhaps the most powerful way that I can really emphasize the need for this bill is just by describing an incident that our office handled a few years ago, where an 8-year-old girl was removed by police from a school bus, taken alone to the police station, and held in question without her parents' knowledge for several hours before being released. And this was all based on unsubstantiated claims from another student that the girl was carrying, quote, chemicals in her backpack. And the interrogation continued even after nothing illicit was found in her possession. So this was obviously a really concerning incident. Generally, juveniles are less able to understand their legal rights while being questioned. It's certainly indisputable that this would be the case for an 8-year-old. And we really shouldn't be allowing circumstances where law enforcement can proceed as if juveniles are informed adults with a full understanding of the scope of their situation. This legislation would rightfully ensure that they have a parent or a guardian present who can support them throughout a police interaction such as this. And we did propose one minor amendment just for clarity purposes, which is contained in our written testimony. But otherwise, we think this legislation is critical just to ensure due process for juveniles, and we hope to see its passage. So thank you for your time. I'd be happy to take any questions.
Any questions? I don't see any. Thank you very much, Hannah. The next witness is Randall Rose. Randall? Randall?
Yes.
You're on the air.
Thank you, Mr. Chair. I too am in support of the bill. I think it is very easy for children to be confused or to be taken advantage of in questioning. I think most of us, if we were questioned by police, would be very careful to make sure that we are not saying anything that could be misinterpreted, but children, of course, don't have the ability to do that to the same extent. It is important for children to have their loved ones with them, to have parents, because they rely on parents for support in a lot of activities, and especially in something as important as encounters with the legal system, the criminal legal system. So this is a good bill. It just makes sure that children have the support of their parents, and that and also will help relieve a lot of parents' concerns when children are in a vulnerable position where they may be charged for things that they have not committed. So those reasons I support the bill. Thank you.
Any questions of Randall Rose? Seeing none, that concludes testimony on Representative Kislak's bill.